Good morning, Whiplash Group members and potential members, medical doctors, chiropractors, PTs, and attorneys. I'm here with Michael Coates today from Personal Injury Made Easy, and we're going to really try to help you with some foundational principles in personal injury to work towards some certification and tested training on some of the basics that we've just got to have in personal injury to make it easy, as his is called. Because personal injury is a beautiful part of healthcare, helping people who have unfortunately had unfortunate circumstances. We want to medically help them get back to maximum medical improvement as best we can. We want to receive fair exchange for those services that we have rendered. In order to do that, we have to work with the right team members, the right attorneys that value us and our skills, besides taking the client that's who they're hired to take care of. But we have to have a team approach. Otherwise, personal injury can get really ugly, and that's what we don't want. We don't want personal injury to become the nightmare where people are like, I'm not even going to do personal injury, or I've been burned too many times in personal injury, so I'm not going to do that, or they become harsh. That's not what we want. We want to make it easy. We want to make it fun. We want to make it positive. So we've got some great stuff to cover today. So Michael, if you could just give us a little background about yourself as an attorney in California and across the country, how you help doctors and attorneys in this area.
Thanks, Dr. J. Actually, let me first hit something you said. And by the way, thank you for all that you do, because you really need the people that care, the people that know, and the people that are willing to teach. And that's you. And I just love how passionate you are about improving chiropractic. When you mentioned about PI, I think, and the image I got as you were talking, it's medical collaboration, right? We need more of that. But really, personal injury is an industry of collaboration, because you got a patient, attorney, and providers. Now there are lanes that each are in and shouldn't be crossing over. So, it's kind of a protected collaboration, but it is there. And the more that you can be able to communicate across those lines and set those right expectations, you don't get the traffic jam along the high profit highway, as I call it. So yeah, I'm Michael Coates. I'm an attorney by background, in California. Been around a long time. I hate to say how many decades, but been way too long. I start off actually as an insurance defense attorney. So in medical malpractice and personal injury defense. So I was dealing with personal injury attorneys, back then. I really didn't deal with providers, being on the insurance side. And that was in the late 80s, early 90s. So it was actually the height of personal injury in the sense of how much the insurance companies were paying out. It was a lot easier then, than now, because they were paying out 3 to 5 times medical specials. That's all changed. It is an industry that has been run by data, by the insurance industries, and applying that data for leverage over the lawyers, and then the lawyers applying it as leverage over you. So I've been, for more than a decade, I got started actually just helping out a buddy, chiropractor, a board-certified sports chiropractor in my local area, when he wanted me to help get paid on 5 patient matters. And I'm going, well, okay, let me just try to help you out. I got him fully paid. His jaw dropped. He said, how the heck did you do that? And I was thinking, why is that a problem? Don't you get paid what your bill and what your worth is? Well, I found that wasn't the case, not only in California. I found out that was the case really around the country. There are lots of awesome attorneys, many of them that are going to be watching here, that really do care, respect, and pay you well. Unfortunately, there are far too many of the other kind. And when I started diving in this, I couldn't believe the things that I came across. Lying, stealing from their own clients. I mean, some really bad stuff. And so over the time, I had championed hundreds of medical providers in all kinds of specialties, with hundreds of law firms, recovering millions of dollars. And that all led me, because, I really found that PI was a broken industry, and I really wanted to help fix it, just like you are. And I think people like you help to fix this, Dr. J. But the only way I can do it is myself also coaching and teaching and training. So, in my Business Advantage program, I kind of hit on, what I call the high profit highway, and the 3 segments of profit, processes, profits, and growth. And I think that that's a great analogy, because I think we're going to get into why PI, and maybe that's best to do. I mean, I speak around the country. I speak at conferences for the pain physician segment, for chiropractic. I have written in articles for all kinds of medical specialties. In the end, it's getting the knowledge out there. You don't know what you don't know. You think you know a lot more than is really there. There isn't an athlete, a business executive that doesn't realize there's so much they don't know and seek to level up. So you've got to embrace the fact there's just so much more that will always be that we don't know. And we got to go to the people that have been in the trenches, battled through it, present wisdom, and can make things a little bit easier for us all. Better, faster, easier. And that's what I think the certification program that you're talking about and all the things that we'll cover even today is a great on-ramp for that process.
Thanks. Yeah, I think that's important that we are always learning and growing because we don't know what we don't know. And the road is often changing. They change codes every year or so. And, they dropped this code, so you can't bill for that anymore. And now you need to combine this in your exam. And so the docs need to know how to do it because insurance does cover 100% of what's medically necessary in personal injury in most states. We'll talk about some certain states like California. They have very strange rules because the Chiropractic Association has let things slip through in legislature that is now capping the docs. They get $70 a visit. They get 20 visits, if I recall right, period. That's all they get. No physical therapy, your re-exams. What has happened that we've allowed that to happen in a state like that? In California, I know when I talk to doctors from California, your cost of living is so much higher than where I am in Utah. And in Utah, I make more on a personal injury case than the doctors in California. They're averaging $90 a visit if they're lucky, when the relative value scales are $250 to $350 a visit for a chiropractor or a physical therapist for these kind of services. So we need to have the right team that's educating us. So I really appreciate that, Michael, you've got a course as well. So let's deep dive into some of these things. Some of the basics is these new docs and attorneys maybe need to learn. What's the difference between PIP and MedPay, and what states, if you're off the cuff, if you know, offer those?
Okay, great example. In personal injury, obviously you're waiting to be paid, right? You're sometimes months, more often it could be years, right? The fast cash and PI are two areas, and they come from the patient's own generally auto policy, and that's medical expense coverage or MedPay, or personal injury protection or PIP. So most all states have MedPay. Even if you've got PIP, oftentimes MedPay is also there. However, there are states that only have PIP. Now, the difference between the two is MedPay only covers medical expenses. Actually, it's the thing I love the most because MedPay is focused for treaters only on medical expense payments. There's less hoops to go through, less of a grind. While, yes, some MedPay insurers try to pull some tricks, and certainly the attorneys do in the area, it's a beautiful thing. PIP covers more than just medical expenses. PIP can cover, and oftentimes does, childcare and lost wages, sometimes funeral expenses, on a death case and things like that. The other thing about PIP is, let's say you're in Florida, Texas, you've got a $2,500 PIP level that you start with. And if it's more severe, it can go up to $10,000. So you get, like in Florida, for example, you got MDs making, certifications that it's a higher injury situation, and then they can access the full PIP. These are generally where it's a PIP state, it's no fault states. So PIP, they thought, was going, by putting this in no fault, it was going to bring down insurance premiums and lower them. That's not what they found. Unfortunately, premiums have kept going up. So if you are in a PIP state, Pennsylvania, Texas, Florida, Michigan, there's so many that you'll find many of those are going to get rid of no fault at some point. Florida probably sooner than the others because it hasn't been working that way. So then you've got the pure MedPay states, whether it's Arizona, California, around the country, that they wouldn't even know what I'm talking about when I say PIP providers there. Just realize it's fast cash. It's things that you want to apply for. A myth that's out there is that the patient thinks, oh my goodness, if I apply for it, my rates will go up. No, rates do not go up because, again, it's no fault on your policy. It doesn't matter who's at fault. It's just a benefit of the policy, right? And you should always be going after it because it's better for your patient. It's bringing down the medical bills. Dollar for dollar as you work, and sometimes you got to battle those guys to get it. Now, in some states, MedPay can pay up to the 100% of what your fee is per code. Where you're going, say, in a Florida, you're actually restricted to like a double Medicare rates, up to 80% of what that charge is. So there's always going to be still some remainder, like in a Florida.
Gotcha. So PIP's part of the policy. It's almost like a medical savings account. MedPay is similar, but it's voluntary. People have to, where PIP is required in that state, MedPay, the individual has to say, oh, I want to add that to my policy. Is that correct?
Well, some states are mandatory PIPs, some are optional. So like, Michigan is a huge PIP entitlement if you want to go up to it. But a lot of these are optional. So that's the whole thing. You've got to really come to understand what is in your state and what is going on, because those vary. And I think the complication in PI is going to come out when you've got a patient who was injured in another state. So you're treating them here, but the PI incident, it's not called them accidents, they're motor vehicle collisions or incidents.
Correct. Docs, remember that. It's not an accident. It's a motor vehicle collision.
Yeah, somebody I want you to say accident. It's that law is going to have an impact. You might be able to still apply. I have seen providers, even in California, get paid by PIP from another state and submitting it. Sometimes they won't allow it. It's going to depend on what's going on. Just know it's an issue, and you can navigate that. And generally, the attorney for the patient is going to be in the state where the accident happened, and they're going to know these laws. So that's part of where you're going to get back into that collaboration to help the patient.
Yeah, and that's an important part. I've noticed that when I work with cases outside the state, like you're talking about, I prefer to have an attorney that I know, like, and trust in my state to collaborate with that attorney and start to work together. You can't always do that, but it just really protects you a lot better, because when you're treating somebody and the attorney's in another state, you're really putting yourself at risk of them at the last minute playing their games. And they might have a different paperwork in their state versus a lien. They might have what do they call it in Texas?
A letter of protection in other states. So a lot of those states, you got the LOP states and the lien states. So a lien is a main contractual agreement. And letters of protection are just a simple letter that comes from the attorney, kind of like a promise to pay, like a paragraph. They're BS. Now some states give them more enforcement, but like anything else, the words matter. You can have a more extensive letter of protection in LOP states. It's just that providers don't know that, and they just accept what the attorneys give. And of course, that gets back to the relationship sometimes. I mean, you mentioned earlier of differences in states. Well, we've got to remember the laws have changed too. Like Florida is trying to deal with a new 2023 Tort Reform Act that was just last summer in 2023 that has put a lot of things on its head. They've gone to a modified comparative fault. If the patient is 50.1% at fault, there's no PI recovery. They change their statute of limitations from 4 years to 2 years. And they can get into the relationship between the provider and the attorney. So as you see, depending upon the state, there are little nuances that do come in. But but when you're dealing on this other state, I believe even in letters of protection states, always have the patient sign a detailed lien agreement, because it's the patient that is generally obligated regardless of the outcome of the case. That's most states. Now, Missouri's an exception. There are a few, but that's generally the rule. And I developed by far the most extensive one over a decade ago, and I've modified it every year when I see the more tricks and tactics that law firms use. I'm always tweaking it, right, and making it better. And I tell you, it is the most protective vehicle that you can have that positions you and protects you when it comes time to be paid. So whatever you're using, realize that most of them just suck. They're just not good, but you can't improve it. So that's one of the things I would pull out and see. And if I had to give you 3 things to just look for, and you'll know really quick, there's a lot of things in a lien, but look to say, does the lien say that you have the patient owes the bill regardless of the outcome of the case? Does it say that specifically? Remember, contracts are how you get the expectations to people. They read, hey, I'm bound to this. So you want that down so everybody sees it, the patient and the attorney. Number 2 is that the attorney owes to you, the provider, a fiduciary duty. That means that's the highest standard of care, and that means the attorney's got to watch your financial back when they receive monies. Really key. And I think the last thing, let me put in for what we're talking about, I've seen way too many tricks with MedPay and PIP. Not only do a lot of the insurers send it to the attorney, even though you've submitted, the attorneys want to hold it till the end of the case as part of the overall recovery.
I see that in California. I've definitely seen that in California. I don't see that in Utah, but
I've seen it in other states too. It's not just California. It's getting around. And in the end, if you put in there a provision that says, that the MedPay or PIP recovered on my bill, has priority, and anything to the contrary in the attorney-patient agreement is rescinded. Like, you need to have where yours governs. And so I think that the things like that, and I'm also a believer that putting an interest provision in. I think you have it contractually, and certainly attorney's fees, because those are things that if you've got an attorney that's trying to screw with you, it's going to give you some other options and leverage that you won't have without those. Interest is your best protection over time. Doesn't mean you charge it, but it certainly means it's going to protect you, because if it's taking years to get paid and somebody's not cooperative, maybe you're not going to waive it. Also, by the way, by being in the contract, it's actually part of the lien. So when they're going to assert to the adjuster of what's owed, it really is the bill and the lien, so it can actually up even the amount a little bit. You can choose to waive it later, but that is what the bill is. So I'm just noting that because, and going back to Florida, here's a game that's being played there. Because of the law change where they can get into the attorney-patient relationship, I should say the law firm provider relationship, a lot of law firms are refusing to sign LOPs, not even to issue them. So you're going naked. And I think it's wrong. I think that law firms are using it to their advantage and shouldn't. And I'm even seeing, by the way, speaking of California, and I've seen in other states, of lien states where the attorneys now are trying to give letters of protection that the states don't even recognize. And they're offering letters of protection to providers instead of the lien to, again, reduce their obligation and their exposure.
Great information. I hope docs are taking notes, paying attention to this, because I believe that the lien is the most important paper in the whole case as far as protecting you and your office to get fair exchange for your services. I love that you put interest in there. I always hear these arguments, nobody charges interest in this profession or in the industry of personal injury. It's like, it's a leveraging tool. It's showing that, look, if you're going to take years to settle this case, we're not a bank, and banks do charge interest. If any business has permission to charge interest after 30 days if something's waiting.
Every single business contract you will look at, your own lease agreement has these are standard commercial business provisions, nothing unusual, anything that at which payment over time, these are natural parts of it. They're just wanting, again, the first liens were created by attorneys who are PI attorneys. So it's meant to be for their favor. And so that's how they do. I'll give you, here's something that I've seen. By the way, some people I respect coming up, shortly, they're missing a lot. But let's say they had the attorney's fee provision, where you got place for the patient to sign and then the attorney, right? Well, they have the patient's signature. Then below it is where they put above the attorney's signature about attorney's fee entitlement. Well, guess what? The patient's not bound to that. It's below their signature, right? Simple things like that is where I find mistakes on a lot of these agreements that I find. So I think for all of you, what do I say? Like, part of when I teach negotiations is trust but verify as one of the principles. And you should maybe trust your document, but verify what it's missing, the problems it causes, and seek to get a better one.
Good. I think that's very sound advice. So I would just add to that with the doctors. I have talked to doctors who say, I never worry about getting a lien. I just trust that they'll work it out. No, that is foolish on your part. You should have a lien. As some doctors I see, I treat to PIP and then it's done because I don't want to have to mess with having an attorney involved. Then you're treating the insurance, not the patient. And that's not ethical. We want to make sure that we treat the patient. And if they need an MRI early and you're still in the PIP, send them out. Sometimes the MRIs will wait on a lien and don't even touch the PIP. But if they do, Your job as the healthcare provider is to make sure you have all the right pieces for proper diagnosis, workup, and to pivot and change through the course of their care. Your job isn't to just get paid the PIP and drop the patient or the med pay. We need to treat this stuff ethically if we're going to be a good doctor in this field. And that's why we want to work with trusted attorneys and have trusted paperwork like Michael's talking about. So please take advice with this.
Like I say, there are incredibly great attorneys that care, are true advocates for their client, the patient, and respect and pay the doctors and pay the full bills, in fact. There's a lot of those. But if you want to relate trust, let me put it to some more common things. Is there any place that you enter into a contractual arrangement that is where you believe it is a lifetime of trust and will never have a problem than marriage? Yet, well, I'm on my second marriage, and Dr. J, you too. So in the end, I don't know about you guys, but the most trusted, sacred area that we think one time we'll never do it, more times than not, doesn't continue. How about, why do we even have wills when we're going to die? Why, if everybody would simply go with what I want? It's because greed, other things take over, or circumstances that change how people do things, and not everybody's the same, right? We have the super ethical, the okay ethical sometimes, and then the mostly unethical and the rarely ethical, right? It's along that whole scale. They exist. You're not going to know who they are a lot of times until stuff happens.
Yep. Absolutely. Man, great information, Michael. I really appreciate this. So let's take a moment to focus on why we do personal injury in the first place.
Yeah, I love YPI. I think the first thing is we got to be honest with everybody, right? Honesty is important, and being transparent. When I do seminars and teach, I talk about, I love movies, and I use the old Clint Eastwood movie, The Good, the Bad, and the Ugly. And, when someone's going to give you the news, do you want the bad news first or the good news? Well, I would usually say, give me the bad news first, because I'm going to end on a high note, right? So let's do that a little bit here on PI. So the bad, it exists, right? We mentioned some, which is you got to wait months, sometimes years to be paid, right? Okay. You're going to have cases that are losers or attorneys lowballing you, right? Even when there's plenty of money. That's just the way that it is. You're going to have adjusters that have no respect for you, that are going to be slashing your bills with the attorneys who are going to roll that ball down the hill also with you. You're going to have, even though you've got a great relationship with the patient, but if there's a pot of money, the patient, you're going to have patients that pot of money is more important than the relationship with you. So there are things like that exist in PI that are the negative side. However, and you say, so why personal injury? Because there's so much more on the good side. Here, let me do something with you. Okay, let me do a little challenge with you, Dr. J. Let's go back and forth on the positives of personal injury and see if we can keep going and putting why this, that I call the high profit highway. Okay, so I'll start out, especially chiropractic. Did you know that in the entire country, there's only one area of in medicine where chiropractic is the lead number one medical specialty in pretty much every state in this country, and it's personal injury.
That's awesome. That's awesome. I love that. Yeah, we're the cat's meow in personal injury, which is, unfortunately, some docs don't realize that to even have the confidence in that. We're great. Another positive is it's the last of the insurance world that actually pays 100% of what's medically necessary, rather than having fee schedules that are hacking you.
So beautifully said. Think of the denials by insurance that you just don't get in PI. Medically necessary, you get paid. In California, what Dr. J was talking about, issues in California, bottom line is they are getting 200 plus per visit in PI in California all the time. Okay. So another one that I'll put, it's got built-in medical collaboration. Chiropractic needs this, right? It needs to get even the respect from the peers, but you also want to get more business? Collaborate with peers who can also give you those referrals. The orthopedists, the neurologists, especially the surgeons, they got to have rehab after. make that arrangement. You're going to get PI and non-PI from those. But PI has a lean network. So you've got to refer to specialists that accept lean or LOP, and they do as well. That built-in collaboration is great for your business.
I love that. I was going to mention on that one because I think as chiropractors, we need that so much because sometimes we become an island rather than venturing out and building those relationships in our network. So the relationship capital, as Garrett Gunderson calls it, when you go out and build those relationships with pain clinic doctors and ER doctors and other surgeons and with the attorneys. So on the flip side of this same coin, I love the relationships we can build with great attorneys in the community that become lifelong friends besides helping you get fair exchange for your services.
By the way, one thing on the lifelong friends, don't put that on social media with the arms around and stuff. Actually, insurance adjusters and people look to go see those and say, they're in cahoots. So that's why you got to be careful. We'll talk about that another time.
Yeah, that is a good point. A good point to be brought up on another time.
Okay, give me another positive.
If you're following research guidelines, this is another nice part. There are research-based guidelines for human occupant injuries in car accidents so that you're not like, even though your opinion as a doctor is a medically valid opinion, besides your own opinion, you have the backup of research to validate frequency of care and length of care to give you some guidelines. So you're seeing patients so frequently, at least the medical doctors, the chiropractors and the physical therapists and massage therapists do this, that you're building relationships with your patients as well. So it's such a great relationship business besides fair equity for the services that you render.
You just said like science-based care, right? Mm-hmm. And that's going to tie you more into the peers, the MD peers, because they are going to be all science-based. So that puts you in alignment. But let me go and following up what you said is another benefit. Believe it or not, you have improved patient outcomes with your personal injury patients. Why is that? Because we would all agree, first of all, chiropractic is, one of the rehab specialties, right? Physical therapy, acupuncture, and chiropractic. When you set up a treatment plan, would you not agree, Dr. J, that if the patient goes with the plan, they have a much higher likelihood of having a healthier outcome, correct?
Absolutely.
Okay. Well, in PI, they have a financial interest, their case, to make their visits, to not have a gap. I mean, it happens at times, but in the end, there's a higher probability of those patients making their treatment, staying on plan, completing the cycle because of the financial interest, which means they actually have an improved health recovery in this injury term care model that is PI. In fact, that's going to lead to a second one that I'll put. The problem with chiropractic is you're on the per visit model. I see your patient today. Let's see if I should see you tomorrow. And then maybe they come, maybe they don't. Well, in PI, it's term injury care. You're going to see them over a period of time in PI. And you're laying that out, and with the No Surprises Act, now you got to lay it out in advance, and put everything down. And that's an advantage, by the way. The fact you got to lay it out in PI, even the price of the whole thing because of the No Surprises Act.
Absolutely.
You've got an attorney, a third party, that then will go tell their own client, that's awesome, great, beautiful. I can use that with the adjuster right now to settle this case, maybe even earlier. Beautiful, right? Whereas a non-PI patient might see a $5,000 total charge that it's going to be and run, not in PI. So, there are more. We probably hit enough for now, but I want you to get the realization that why PI is because it really is the high profit highway, and it's not just about money. High profit is not just financial. Profit comes from an easier way to do business. You've got less paperwork than insurance. You don't have to chase, don't need patient financials, all those things. It's just higher profit, less stress, better relationships. There's just so much to profit from in personal injury. It's just the best to be in. And if you're not in it, I think you're just crazy. I don't believe, by the way, in a 100% PI practice, because I think you're missing the beautiful synchronicity between wellness care and injury care. They're two sides of the same coin. They feed each other, and patients on both sides will feed each other. And you want that diversified, healthy practice. You need both.
I can't emphasize that enough to the chiropractic physicians out there, which is why with the Whiplash group, we're trying to introduce you to coaches like CJ Mertz, who talks about care plans being time-based. We heal over time, not a number of visits. Of course, we have to speak visits for insurance purposes, but when we have corrective care patients and wellness patients, a lot of our personal injury will come from those. A lot of our personal injury patients, when we're educating them properly, which we'll do in another training, will convert over to wellness patients where we might end up with lifetime patients from these, which is a great point. I do want to emphasize, and I think this is an important test component, is when we're using the Croft guidelines, which we'll deep dive in another time, these research-based guidelines that are recommending 6 months or a year's worth of care based on time and frequency and injury and workup and diagnosis. And if we look at Dr. Havock's work, the chiropractic researcher from New Zealand, she points out that in the years since the Croft guidelines came out 34 years ago, 3 times a week or more is what the research shows, whether you're going to the gym, the physical therapist, the chiropractor, over a period of time, 12 weeks or so, that we can re-educate the tissues to have a lasting effect. If we're doing less than that, once or twice a week, that's wellness care. So we need to understand these things so we are prescribing the correct amount of time and the right frequency and time, as Michael was addressing. People don't heal in a number of visits, they heal over time, but they have to have the frequency of those visits in that time frame.
Something that is viewed as a real negative, and some of you, when I say these 3 words, you won't even have heard them before, but you're going to, and you're going to need to comply. No Surprises Act. Okay? Mm-hmm. The NSA is mandating you to give a good faith estimate, which is all of the what, the when, and how much, completely detailed injury care plan in advance of care, or at least by the second visit. But here's the advantage that I want to tie into when we're talking about injury care and wellness care in those 2 parts, is that the NSA is actually kind of like improved patient outcomes. This ANPI really augments it, because the more that the patient gets involved in the understanding of the plan, of what you're doing and why you're doing it, right? Mm-hmm. And they become more of a partner. Again, is going to help with more compliance, because they're understanding the what, the when, the how much, and you're going to talk about the why. Okay. Right. Now, as you do that in injury care, they're getting used to what? A new habit. They're getting used to that habit, like you're saying, Dr. J, of when I see Dr. J over time, I get healthy. This is a really good thing. I feel better. By the way, they feel extra good because they got money out of their PI case too from the great attorneys, right? Now they've been discharged from injury care. That's not where it ends for you. You now have this bridge, and it's going to come the bridge into the maintenance wellness care side. So when you show them this injury care plan, now you're just going to show them a brand new document, exactly the same, called wellness care plan, laying it out the same way you did what the NSA requires for injury care, and they've already seen it. They've already signed off on it. They had an attorney saying it was great. This one is lower price, less involved. Oh, sure. Okay, yeah, let's do that. Now, not everyone's going to do it, but you're going to realize that this becomes a very powerful way to help to transition away from that, per visit model that chiropractic has into a term care model using federal law that you have to comply with whether you like it or not. Because you got to do those with every uninsured and self-pay patient. Every PI patient is a self-pay patient because they may have to pay even if there's PIP, even if there's MedPay. There's no guarantee that those cover it, and there's no guarantee that a PI case wins. No attorney will ever guarantee it. Neither can you.
Thank you for clarifying that. I think that's important because some docs go in and they're chasing, quote, easy money with insurance, not realizing the patient is responsible for that, period. That you're treating the patient, not the insurance company. Oh, that's really good stuff. And I love how that act has helped us with more doctors. We've always done this where the upfront pricing, showing them, look, you came in as a grade 2 or a grade 3 or a grade 4 in the Croft guidelines. Here's the estimated treatment protocols. Here's the estimated cost. So they know up front. And sometimes they'll get big eyes like, oh my gosh, it's $8,000 or $10,000 or $12,000. And I tell them, look, I went to the emergency room after my DeLorean crash and I spent 14 grand in imaging in 90 minutes. That was no treatment. That was just taking pictures. This is 5 or 6 months worth of care. This is a great deal. Oh yeah, that makes sense. This is like paying for braces for your kids' teeth, but it's rehabbing you from these injuries that you received that you didn't choose to receive these. It happened. It was just a motor vehicle collision. This is, let's get you back to maximum medical improvement. They appreciate that. And it's the same, like you said, with cash patients, showing them upfront pricing. It's the ethical way to do it.
Now let me say just a couple more things of the NSA, just to kind of close it out. It's really involved. I mean, I teach around the country, and I do a lot of deeper dives with my Business Advantage program members. But I want you to realize the negative side on it too, and that is, you haven't. This was into effect, over 2 years ago.
What year did it come out? 2022, something like that.
2022, yeah, January 1. And if you only heard about it now, that means you're 2 years behind on every patient you treated. Here's the problem. If those patients, you can't show and prove that they got your detailed bill, they received it, not the attorney, they received it. That patient for $25 could go onto an online portal, just check out, go to cms.gov/no surprises. It'll send you to it. For $25, they could possibly not only get out of the bill if it hasn't been paid yet, but let's say you've been paid by the attorney. They could actually have it where you got to pay the patient back with interest.
Wow.
So I suggest you catch up on this fast. There's a way to catch up. Even though you didn't comply for 2 years, I think I talked to my Business Advantage program members, I call my NSA hack. So there are ways to catch up, but at least be honest going forward and just learn this. It's important. It's not going away. HIPAA didn't go away. HIPAA's only got more enforceability, and it's going to happen here too with this law. The current presidential administration is going to parade this around during the presidential election. This is how they're going after to solve the medical debt. So as they apprise more people are going to try to take advantage of this.
Great information for all of us doctors to know across our specialties, medical, PT, chiropractic. I definitely highly encourage people to do this. It's not just for fun. This is the law. We got to do it. For those of you that are Whiplash Group members, we do have on the website, on the private website, a form that you can just download to give your people on your financial day of here's the projected cost so that you can be upfront with that.
Got to be specific in alignment with CMS, with the Center for Medicaid and Medicare Services, right? So a lot of you go, oh, I give my fee, my list of fees. No, that doesn't work. You literally got to give. Here are the dates I'm going to see you. Here's a calendar. Here are the dates. Here's what I'm doing on each of those dates. Here are the modalities. And here's the cost. Mm-hmm. You've got to be that detailed. That's why I want you to think of it as a term care plan where you literally would lay things out in a care plan that you presented to someone to sign off on.
Awesome. Great. Thanks. I'm pretty sure the form meets those needs, but I'll have you look over it and double check it. So we're up to, I just want to talk about how important it is to feel that we're getting fair exchange for our time and talents and deliver the services. In the Whiplash Group, we're very much focused on income as a byproduct of service. So serve outstandingly so you can receive those outstanding payments by working with the right team of attorneys and such, and treating your patient properly, treating them, not the insurance. I sometimes hear from different states and from attorneys who are not versed in working in personal injury. I had an attorney just this last month that knows nothing of personal injury, and somehow he ended up with a PI case and was calling me asking questions. And every time I give him an answer, there was this long pause of, I could tell he was in the deep end of what he didn't expect. He didn't know that area of law. But oftentimes I'll get a call from an out-of-state attorney, some from California or Texas. Oh my gosh, I can't believe your fee is over $3,000, over $5,000. No attorney, no chiropractor charges over that. Our state doesn't allow that. What's your take on that?
That's a bunch of hogwash.
Right?
Well, first of all, when you mentioned the part about, the attorney that had done PI, just a little tip for you. Whenever you get an attorney you're unfamiliar with, go to their website. If their website says like family law, business law, personal injury, if personal injury is not the soul of the only thing of what they do, PI is an add-on. They just don't want to lose clients to others, and they add this on, so they're not really skilled with the sole personal injury attorneys, and they make more missteps. They get less recoveries, and you've got to be a little more careful where you've got extended treatment. Small treatment, small bills, not as big of a risk. But as that gets bigger, you've got to be more careful, right? I'm sorry, I forgot the question now. I was leaving on there.
Oh, with some of these states or some of these attorneys say, if the fee's over X amount of dollars, then it's like,
the bill size.
Yeah.
Look, there are medical billing experts that will testify in court. And what they'll testify to is the standard is not what is the lowest billing rate. The standard is not Medicare. The standard is not in-network health insurance. The standard in PI is out-of-network charges. Okay. So, and it's not just the average out-of-network charges. You can literally, and a billing expert will justify at 90% of what the upper limit of the charge is as reasonable. Now you're going by geographic area and specialty. You can use one of the UCR publications that are there, or even there's some online, fairhealthconsumer.org, is one. And I like to have that used because it works great with adjusters and attorneys to just double check fees. Great for chiropractic, by the way. But what you're trying to do is to justify your billings to the attorney. And this is always a pushback you're going to get. You're going to get it no matter where you're at, because that's what the adjusters are doing to the attorneys. Unfortunately, not a lot of the attorneys are pushing back on the adjusters to support and justify your bill. What they should do is, hey, if an adjuster is saying, here's by spit on Colossus, here's all this person's supposed to get. They should be sending that to you, and you can fire back an easy justification laying out how, no, that's wrong, and this is right, and this is proper, right? Colossus is not an expert in court anywhere. It's software developed by the industry, and there's other softwares that insurance companies use. It's for their own benefit to lower fees. So the attorneys are kind of regurgitating what they're getting from the adjusters. Don't let them do it. What you need to do, and this is part of that process, is the prep work. You need to set reasonable fees. What are those? So you've got to go about determining and setting what are those justifiable fees, and you want to have third-party support of that. And in PI, it's not just the fees. Like, look, you could have all your fees right in alignment with everything. But there are providers who improperly apply codes. I'll give you an example. It's called upcoding. You might have the same patient, the exact same injury, the exact same body type, everything the same. But because it's a PI case, they added another code. That's medical billing fraud. They've upcoded merely to increase things. And that is becoming, by the way, upcoding, treating all PI patients as cookie cutter, as a larger danger that's coming even with insurance companies. If we have time later, it's this new predetermined protocol litigation that's going on in the PIP states. So if we have time, we'll hit that too. But don't accept what the attorney is simply saying when they're trying to, ridicule your bill. Get not only that fee support, but have the proof of past full payments of your bills. What's better evidence that you're worth what you charge if you've got MedPay that has paid, in fact, your full bill, your full charges? You've got attorneys who have, in fact, paid your full bill, your full charges. I mean, redact things so you're protecting patient privacy and all that, but you could assemble that proof, and it's very, very powerful to go back against the attorneys.
Wow. I love how articulately you share everything you've shared today, Michael. You're so good at helping us better understand some of these dark corners in personal injury that should be. Let's just shine a light on them and let's just all understand this stuff better.
Well, let me add to this. Here's the thing on fees. If you do this area right, see, I'm a big believer in, if you want more from the good attorneys, and what you should be doing is learning how to be a value driver. 1,000 providers, thousands of providers in the country that do good treatment. How do you differentiate yourself? That's one of the things that PI allows, because when you learn different documentation techniques, the things that are unique to PI, how to be a value driver, maintaining your neutrality, you become separated from your peers, more desired by the good attorneys. You literally can learn how to help the attorneys get higher settlement recoveries. all because of the way you managed a PI case. Fees are a great example that we talked about. If you can develop the right support and get it to them early, and they can deal and battle with the adjuster before a case settles that negates them cutting it down, that means they just increase the settlement value of that case. Who do you think that attorney wants to send the next client to?
Right.
You, because you're different than the others. Learn all the ways to be a value driver, learn how to communicate that to the good attorneys, and integrity matters and character counts. Do what you say when you say you're going to do it, and never, ever, ever go on the other side of the ethical line. It's never worth it.
Never worth it. We drive that point. I'm glad you do with personal injury made easy with Whiplash Group. We really drive the ethical line there. We've got to draw that line and stick with it. And I think the way that we get those values that you're talking about, if somebody went to a surgeon, they're going to work up and diagnose that patient with the value drivers to substantiate their surgery, their work that they're going to do. We need to do the same thing. Oftentimes we should always be requesting records, like 5 years of records when a new PI patient comes in. We need to look back and see what they've had, what care they've had or haven't had, or if there's been gaps in care. We need to know that stuff so we don't get blindsided. Now, I oftentimes get the records from the ER or urgent care if they went to one, and they have 2 diagnostic codes. Driver or occupant of the motor vehicle collision, soft tissue injury or whiplash, that's it. That is, as value drivers, we need to do a workup and diagnosis, since our specialty is personal injury, with 30 or 40 working diagnoses that we're like, these are some things we're concerned with, or this patient may have, or definitely has. And that's why we do re-exams, so we can alter and subtract or add as we need to through the course of care. But if we don't diagnose it, if we don't have those value drivers there, like Michael's talking about, it never happened. It doesn't exist. We have to have it in writing. So we need to be looking for those right things. A concussion.
Yeah. Well, there's also, there's not just value drivers, but the problem that a lot of medical providers do, and it's not just chiropractic, it's all medical specialties, things that harm a PI case. A simple one, and I've done this because you see me talk to people about this before, is, do you have patients diagram accidents? If so, stop, right? Like, you are literally potentially creating a liability situation that didn't exist before you had the patient do that. You're not an accident reconstructionist, neither are they. And if you're in one of the states, whether you're in Texas, Florida, others, where you've got a modified comparative fault, you may have now completely undercut the entire ability to recover anything from the case because you did a misstep of allowing that patient, and sometimes I've seen providers diagram it themselves in their notes. You don't need to know the speed, how fast were they going? You need to know front, side, rear. How'd the body move? Did it hit anything? Great. But don't get into the angle of impact, the speed that they were going. Did they go through a stop sign? That's not you. Stay out of the attorney lane. Let them do their thing and don't muck it up.
On that, let me ask you this question. If the doctor was to have a diagram and put something for doctor's use only to try to see if there's a torque component besides just a direct rear impact component, something like that, so they can see, well, what forces might have been applied to the human occupant, but they're not accident reconstruction. What about something like that?
Not worth the risk. First of all, you're still assuming someone's going to do it properly. But here's the bigger assumption. Remember the person that's going to use this. What I used to do, the savvy defense attorney. Believe me, you may have all the good purpose in the world. I'm going to take that. I'm going to make it look like I'm going to make it to my advantage. And no plaintiff attorney is going to like that. Now, later on, after you treat it, remember, attorneys can use you as an expert. In fact, you should never be testifying unless you're being paid as an expert. That's a whole other thing, right? Unless you're reading your notes. But later on, you can be given by the attorney things like that. And then give those opinions about impact and stuff and torque. I would just, in PI, I would be really, really careful of that, only because the potential for not doing it properly and also the potential for misuse.
Great advice on that. So we usually have some little matchbox cars so that the patient can show us, but that's not documented in their file anywhere. They're explaining to us what they think happened, but like you said, they may not remember it perfectly.
I have one guy I remember at a conference, and as he pulled, he said, "Yeah, these matchbox cars behind," and have the patient pull up the one that looks like his and the other guy, and I videotape them. And as he shows me how it happened, I went, oh no, now a videotape, right? I'm again just going to say there's ways to do front, back, side impact, and then just go on how the body moved in the car, where the body went in the car. Don't focus on the exterior of the car. Focus on the interior of the car, of what happened with the body. Because I think would you not be able to get, Dr. J, the same kind of information, that way? At least enough to give you at least approximately what you're trying to get. I mean, there are others. If you want to be an accident reconstructionist, go for it. Take all those things. If you are, then, and if you believe the patient is not going to maybe misstate it, hey, I guess go for it. I still think you're causing a problem.
No, that's all sound advice. I know some of our other attorneys have asked us to not, because we don't know how fast. How fast were you going? Oh, I was going 35. They were going 70. And the car's got this tiny little scratch on it. It's like, that is not accurate. So we don't want to put that in there. But we can ask, and you correct me if I'm wrong, because this is for me to learn just as well as everybody else here. Our other attorneys have asked, did the airbags deploy? Which tells us it's a high-speed collision. So you can say a high-speed or high-force collision. If they didn't, it was a low-speed or low-force collision. That's all you need. You don't need to be putting down we didn't have a radar gun on them to see how fast they were going.
Well, but what you're unfortunately diving into is something the insurance company they like kind of like accident. Only high-speed collision causes significant injuries. We all know even low-impact collisions can cause a lot of harm. This is where when you find as a value driver, when you discover pre-existing conditions, and there's stuff you need to do to pull that out. But when you do, it actually often is the goal to PI. Because if it's got prior imaging, for example, compared to current imaging, now there's no question that this accident caused more damage. Or maybe because of the prior injury, they're more susceptible to harm. So even though it's a lower injury collision, because of their pre-existing conditions, their comorbidities, that's made them more likely to get more seriously injured than what you might term as a more typical person. And so all those things do come into play, and you got to be careful about getting involved in the low impact, medium impact, high impact. I'm going to still say that's back to the attorney. I do think facts. A low, medium, or high is a conclusion. You should not be making conclusions. A fact is, like you put, the airbags deployed. Absolutely. That's important. Seatbelt. Absolutely, right? Where did my head go? What angle did my head go? Okay. That's all important for how you're diagnosing the issue. By the way, and speaking of diagnosis and value drivers, the name of our industry, let's see, personal
injury.
Right. So what kind of codes do you have that you can apply to injured patients that might have a little bit more of an impact, there's another pun intended, in personal injury? Trauma codes. Why aren't you using those? They're there and right before you, like the low-hanging fruit for how you're coding in PI. And so I see so many that don't utilize the trauma codes, right? Like, what are you doing?
We'll deep dive into this in our report building module, but good stuff. See, if we don't begin, docs, if we don't begin with the end in mind, if we don't document with the right things that the attorneys can then leverage for the patient, it becomes a lose-lose-lose scenario. To make it a win-win-win, we all have to stay in our lane, do the best job we can at what we're good at, and voila, the patient comes out ahead, we get paid fair for our exchange, the attorneys get paid fair for their hard work. It's just another beautiful part of personal injury when we do it right.
So well said. And when you do it right and avoid the wrongs, because there's that too.
There are other pitfalls to avoid. So I would just like to emphasize the exciting part about you working towards certification in this module and the other modules that are available is in the medical world, they have areas of specialty and diplomate. In chiropractic, we have that as well. We have 43 different areas of diplomate specialty, from pediatric chiropractor to sports chiropractic to neurology chiropractic, neurology specialist, and in personal injury. So please get certified and don't dip your toe in the water. Don't dabble in personal injury. Black belt it. Learn the Aikido stuff, the Aikido negotiations from PI Made Easy. Let's do this right. It's way more fun, and we help our patients tremendously. And just to kind of close on some of the income potential from this, I'm going to encourage you to not just do these little certification things, but go learn from Michael and his program. Get certified with Dr. States. I got certified with Dr. States in 2002 or 2003. It doubled my case value averages. I look back at my career, and it's well over $1 million of money I made that I wouldn't have made, and I did that ethically and properly, helping serve people better in personal injury. It's the ROI on doing these things, like what Michael's teaching and what we're teaching and what Dr. States is teaching, is incredible. Another great one, Dr. Katz. Oftentimes he posts $20,000, $19,000 checks just for the chiropractic care portion of his services because he's so research-based. He's objectively backed up all the care that he's doing, that the attorneys can then do their job and everybody wins. So I don't want you to put a cap on. It's like, oh, I'm just going to chase the PIP, the 3,000 or the 2,000 or whatever, depending on your state, and jump out. That is not serving to our best potential. So,
but let's get, let me put a little reality in some of this too, though. So it's my own perspective, right? But from not only what I've been in the middle of and what I see all the time. Less than 4% of personal injury matters actually go to trial, right? So most every case you're ever going to have is going to settle at one point or another. Most settle before a complaint's even filed. And the rest of the majority are settled well before they even get to an expert deposition. So it's much earlier in the case. And in the end, you're going to find that the most important thing for you, the chiropractor, is your notes, not your report. It's the notes that are the basis. Reports, again, can be long, too long, have things that can actually, a good defense attorney can find things more to attack than having good notes. But the thing when you're putting like studies and things on it, in the end, adjusters all these things are being settled. They're settled by non-medical providers, adjusters, attorneys, patients. So it's great to have on the case that has a much better chance of going to trial, really big injuries, that more supportive study, other things that if you had to go where experts are testifying, great, we got it. That's going to be far less than 20% of the matters out there. I mean, by a long shot, okay? 80% or more, it's not that. And in fact, when it comes time to be paid, even when you've done everything right, they're still going to seek to pay you less than your full bill, because that's what's become a habit in PI. And attorneys have learned from others, hey, look, we put an aside for us, an aside for our client, and then we put the rest to split between the medical providers. In the end, lower settlements, reasons they don't want to go to trial and not do it anymore and take a lower settlement, we're going to put on the back of the provider. So you got to learn that even when you've done it right, you still have to get the skills to negotiate with attorneys to get paid what you've earned and what you deserve. And I think there's a misnomer on negotiation. People think, oh, we'll negotiate. We got to meet somewhere in the middle. Chris Voss was an FBI negotiator, and he did a book called Never Split the Difference. And I still believe in that. The moment you say I'm going to split the difference, you lost, right? Yeah. Negotiating means discussing and position and asserting your side and your position. It doesn't mean you're going to take less. It's a matter of communication. So one thing that I have, my extra niche, besides really focusing on processes and growth, the beginning and end part of the high profit highway, that middle part, which is the treacherous, windy part, is getting paid. So I have a 2-day training I welcome you all to do as well. Actually, it's a day and a half. And it's called Negotiations Aikido. So Aikido, if you know the martial art, it's utilizing the energy, size, and tendencies of the viewed as the much larger opponent and much more powerful against them, offensively and defensively. You get the advantage. You put them on the mat. You win. So I developed over all this time for my negotiations Aikido, it's called the disruptive method of lean negotiation. And it's like a set of tiles. When you line up, each letter of disruptive means something. When you align them properly and you set the first one in motion, just like a set of dominoes, success is inevitable. They fall down. You get paid more. It's not just ROI, but it's ROR. It's your return on investment, it's your short term, and ROR, your return on relationship. So I invite you to attend and start to learn about negotiations Aikido. I certainly encourage you to, no matter what you do, you must learn about dealing with attorneys and how to out-negotiate them when you're a healer and a giver. It's a fight that you think that you're less armed for, and you actually have the advantage. You just got to learn what they are and how to use them. And of course, by the way, I hope you do look to explore my own program, which is much broader than negotiations Aikido. It's called the Business Advantage Program. And simply go to personalinjurymadeeasy.com, and you'll see about the 3 segments of the high profit highway that I talk about there, and see if the fit is right for you, because this is all about you. It's about your business objectives and your personal dreams, because we live in a society where they're tied together now. They're not separate, right? And
Nice.
both Dr. J and I want success for you. So being through the certification, through the things Dr. J brings to you, through the experts he brings you, get all the coaches you need in all the areas you need, because together, that's going to get you the business team that you need, like the patient needs the healthcare team.
Thanks for great information today. Really appreciate you taking some time, Michael. Look forward to seeing you at future events and opportunities for us to teach, share, and elevate our profession.
Thank you, Dr. J, for all you do. Really appreciate it.